Thank you very much for joining us. This is our 11th lecture on UAE Economic Substance Regulations, and we are discussing relevant activities. Today we are discussing intellectual property business. After this, we will have one more lecture in which we will discuss distribution and service center business. Intellectual property business. So first of all, we will try to understand what is intellectual property business. They said if a licensee holds any intellectual property asset and from this asset a licensee is earning any separately identifiable income, then it will be considered that licensee is conducting intellectual property business. So two things are important. First is intellectual property asset, IPA. Second one is income. So what is intellectual property asset? They said this is a right in the intangible assets such as copyrights, patents, trademark, brands and technical know-how. Now what is income? They said this income from the intellectual property assets can be in the form of royalties, it can be franchisee fee, it can be licensee fee, it can be capital gains, or it can be from the sales of the intellectual property asset. So if licensee is earning any separately identifiable income from the intellectual property asset, classification of the income in the books of account is very important. Royalties required to be considered as royalties. Franchisee fee required to be considered as a franchisee fee. Intellectual property business can be classified into two categories. First, it can be high risk intellectual property business. Second is a non-high risk intellectual property business. For the high risk intellectual property business, they said if any of the following two conditions is filled, either A is being fulfilled or B is being fulfilled, then it will be considered that licensee is conducting highly risk or high risk intellectual property business. In the condition first, they said if all these three conditions are being fulfilled, then it will be considered that licensee is conducting high risk IPB. Out of this, first condition is that the intellectual property asset which is being held by the licensee has not created that asset, but licensee has acquired this asset from a group company or from a third party out of UAE through funding research and development. And third condition is the licensee is earning income from that asset from the group companies. So we can say there are three conditions. First, licensee has not created the asset. Second, licensee has acquired the asset from a group company or from a third company which is based out of UAE, but it has been funded through the research and development. And third condition is licensee is earning income from the group companies. If these three conditions are being fulfilled, then we will say that licensee is conducting high risk IP business. And in the next class, they said if the licensee does not carry out research and development or branding, marketing, distribution of its state core income generating activities, and licensee is earning income from such intangible asset, then it will be considered high risk intellectual property business. The second class is non-high risk intellectual property business, means any other intellectual property business which is not meeting condition A or condition B, then it will be considered non-high risk intellectual property business. We need to assess if the business has a right in the intellectual property asset. Yes. From this right, business is earning any gross income. Yes. Then this gross income is separately identifiable. Yes. If these three conditions are being fulfilled, then we will say the licensee is conducting intellectual property business. If A is being fulfilled, B is being fulfilled, in the third category, income cannot be separately identifiable, then it will be considered that licensee is not conducting intellectual property business. It means licensee will not be earning separately identifiable income. It will be considered that the licensee is using the license, patent, trademark or intellectual property for normal business purposes. Might be this intellectual property will be creating intrinsic value in the business. Just I can say I have this trademark, I have this registered trademark in UK. I am not selling this trademark to any third party or any group company, but I am utilizing it for my school, which is Kress e-learning school. So it will be considered that this brand will create intrinsic value in the business, but it will not be considered intellectual property business. So if this is not an intellectual property business, income cannot be identifiable separately, then we will say it will not be subject to ESR. If all these three conditions are being fulfilled, then we will say the licensee is conducting intellectual property business. This intellectual property business can be high risk intellectual property business or non-high risk intellectual property business. If this is high risk intellectual property business, it has been given in the guide that by default it will be assumed that licensee has failed economic substance test. Here it will be assumed that licensee has satisfied economic substance test. If the licensee has failed the economic substance test, licensee will be required to provide evidence to the regulatory authority about the development, enhancement, maintenance, protection and exploitation of the intellectual property asset. Here licensee will be required to provide this information if required by the regulatory authority. In case of high risk intellectual property business, by default regulatory authority will provide information to local competent authority. Here regulatory authority will provide information to local competent authority if the licensee has not satisfied the economic substance test. In case of high risk intellectual property business, local competent authority will provide information to foreign competent authority. In case of non-high risk intellectual property business, local competent authority will provide the information to the foreign competent authority if the licensee has not satisfied the economic substance test. In case of high risk intellectual property business, licensee by default will be required to provide the information to the regulatory authority that the licensee has satisfied SIGA test, management test and adequacy test. For this purposes, licensee will share the business plan, licensee will provide employees information, licensee will prove that SIGA activities has been carried out in UAE, licensee will prove that there are adequate expenditures in UAE. All these information will be provided by the licensee by default to the regulatory authority. Here in this case, non-high risk intellectual property business, licensee will provide all this information if required by the regulatory authority. SIGA test, core income generating activities for the intellectual property business. They said core income generating activities for the intellectual property business depends upon the nature and the way intellectual property asset has been utilized by the licensee to earn the income. In the guide, they have classified this into two categories. First, they said this is a patent and similar assets. Then they said these are marketing intangibles. If these are marketing intangibles, then it will be definitely relating to the marketing activities, important promotional values, it will be relating to branding, marketing and distribution. While in case of patent and similar asset, they said a patent or any other similar assets like copyright software, technical know-how, useful protected asset, research and development, all these will be classified under the patent, and all intangible asset related to the marketing activity, they will be classified under the marketing intangibles. For the patent and similar assets, core income generating activities should be in UAE, and these activities would be planning and development, prototyping, demonstrating, piloting, testing, validation, applying research, finding, product process. All these things related to the development of the patent or related asset required to be conducted in UAE. If all these activities are being conducted in UAE, then we will say the patents and the similar assets are meeting the economic substance test. While in case of intangible assets, they said all activities of marketing intangibles like planning, designing, development, execution, all these activities required to be conducted in UAE. Moreover, they said that mere periodic decision taken by the non-resident director won't be sufficient to satisfy the economic substance test. Now we'll discuss some examples. In the first example, they said licensee holds a brand which are licensed to other in return for loyalty. It means licensee as a brand, licensee is given against the loyalty to other people, so it will be considered non-high risk IP business, so it will be subject to ESR. In the second example, they said there is a chocolate company. This chocolate company has its own trademark. This trademark is being used for the business purposes, so it will not be subject to ESR because this is not intellectual property business. In the third category, they said the software company, this software company has developed IT software and this software is being given to other company against which company is charging licensee fee, so it will be considered non-high risk IP business and it will be subject to ESR. In the fourth category, they said there is a company which the name of the company is a pharma corporation. This company has taken one intellectual property from its UK company, then further lease it out to a company which is based in KSA and Egypt, but the company itself is based in UAE. So this UAE based company has taken intellectual property from a connected person from his group company and given it on lease to its group company, so it will be considered high risk IP business and it will be subject to enhanced economic substance test requirement. Yesterday I have received two questions from someone. They were asking, one company A, this company has territorial rights in UAE. These territorial rights they are subletting for any specific shipment. Will it be subject to ESR or not? I am leaving this question for you. Next, they said another company, another group company, holding company, this company has taken license from Oracle USA and this holding company is subletting this license to other group companies and this company is charging to other group companies. So will it be subject to ESR or not? I am also leaving this question for you. Thank you very much for joining us.